Good afternoon, everyone. Welcome to the last week, that is week 8 of this problem solving session related to principle of construction management course. I am your TA for this course. Let me share my screen first. I hope the slides are visible to everyone. So let's start the
Yes, sir.
class.
Yes, sir.
Okay. So this is the way week 8 of this principle of construction management course, or you can say the last week, wherein what we try to cover, we will try to cover the concepts related to construction management and then contract management and few concepts related to what are the ethics principles you require to be followed during your construction work. So my name is Pranam Mahajan. I am a PMRF scholar in Department of Civil Engineering from Structural Engineering Division from IIT Madras. So let's start the class. So what you saw in the previous week is how the quality control related to various works that are required to be carried out in the site, how quality assurance for that can be quantified or can be qualitatively determined. So for that, we have seen the different measures that can be adopted regarding various things, like you can say in the reinforcement bars, you have seen to prevent them from corrosion, epoxy coatings we require to be provided. So that should be provided in that areas where corrosion rate is very high compared to the regions where the corrosion rate is very less. Because if you provide the epoxy coating to every bar, then it becomes uneconomical for you also to work in different areas. Safety is important, but economic of the projects is also important. So that should also be taken into consideration while managing a particular work that is required to be done at particular site. And moreover, this all these things are based upon what kind of contract is given to you, what kind of specification is provided to you, whether the clients wanted to provide such quality assurance or qualitative preventing uh, measures that are required to be followed so as to protect the structure from the degradation that happens to its working during its construction as well as during its operation phase. Because after the construction is completed, inside the material what is happening no one knows. So to prevent that, proper measures should be taken before the work should be completed so that the rate of degradation of the structure should be reduced as compared to the one which will accelerate the degradation and will reduce the remaining life of the structure in your during the operation phase of the project, and thus will not serve the purpose for which the project is created. So for the final week, we will see some guidelines related to what uh, Indian codes, or you can say municipalities, have created so that you should be in the proper limit within the boundaries that are created. And then we will see how different types of contracts are there, how they differ from each other. Then we will see regarding a new advancement in contracts, that is credit contracts as well as PPP model that are generally nowadays applied by NHAI and different various roadways projects. And finally, we will conclude with some definitions regarding assets, liabilities, and or giving you an overview about ethics. And this will conclude your course for the principle of construction management. So for this, what are generally building bylaws? So building bylaws are legal tools which helps you to regulate the coverage, height, building bulk, its architectural design, the construct, or you can say the construction aspects of the building, so as to have an orderly development in an area. So these are generally defined by the municipal corporation, or you can say the area locality, who will govern that whether the building that should be created will not cause an obstruction to the roads, or you can say the commuting public in the roads, or you can say the traffic that is passing in the nearby areas. So obstruction to that public will not be happen because of the construction of your building based upon the dimension you consider to be desirable as as for your purpose. So what are the objective of building bylaws? So these bylaws helps you to promote planned urban development. It also helps you to ensure health, safety, and comfort of the public. Another advantage is it helps you to protect your buildings against fire, earthquake, noise, structure failures, and any other hazards related to different issues that may occur. Or you can say electric shocks, or you can say electric electric currents that may happen to be followed in the buildings. So that helps you to protect them from building to from each other. So these guidelines helps the architects as well as the engineers for designing as well as the construction of buildings. So this helps you to maintain a balance between a built as well as the natural environment. So the buildings that you are creating should not affect the natural environment that is already present in that area. Now talking about few definitions. So what is building line? So building line is the line with up to which the plinth of the building adjoining a street or an extension of a street or an future street may lawfully extend and includes the lines prescribed, if any, in any scheme and or development plan. This building line may change from time to time as decided by the authority. So each and every word in this is important. First is building adjoining to the street, then extension of a street, future street that may lawfully extend and include the lines prescribed and in development plan. Okay, so wherever up to the length, your length of the building is moving, that is considered to be the building line of that particular building. So you can say you have one plot. So this is your plot. I can use different color. So suppose this is your plot. Okay, this is some other plot. This is some other plot, and you are making the building inside the your structure. So the line at which you have put your plinth, this line is considered to be the building line of the project. Okay. Now what are setbacks? Okay, so setbacks are defined as the minimum distance measured between the front and the rear side, front, rear, and the side of the building, and respective plot boundaries. So you can see whenever you have a plot in front of you, you will keep some distance for the lawn purpose or some other purpose. Insides also you keep some distance, and at the back also you are supposed to keep some distance. So these distance are also prescribed by the in are also prescribed in building bylaws, and also sometimes governed by the municipal limits that are provided in that area. So the minimum distance measured between the front, rear, and the side of the building and the respective boundaries is defined as the setback distance. So the distances and the provision of the open space are dependent upon the plot size. So dependent upon your plot size, your front, back, and the side setbacks depends. So building construction restricted to the lines of setbacks. That means you can't construct your building beyond the limits that are prescribed by the setback distance based upon the area of the project that you are able required to construct. Now, what is ground coverage or ground coverage? The area, or you can say ground area, covered immediately above the plinth level, covered by a building, but it does not include the space covered by garden, rotary, well and well structure, plant nursery, and many other things like water pool, swimming pool, platform around a tree, or you can say your recreational purpose things that are there. You can say like fountain, bench, chabutra, or unenclosed space on the sides by the walls, drainage, culverts, compound wall, gates, canopy, chhaja, staircases, and which are open, which are uncovered and open at all the three sides of the building and are open to sky. So anything which is open to sky and outside your building is considered to be not considered in the ground coverage. So the floor that you have created above the plinth level, which is covered by slab in all the region, is considered to be your ground coverage. Okay. So these definitions are important because that will helps you in later stage to implement your project based upon the municipal limits as well as the building bylaws of that area. So talking about the technical definition, what is ground coverage? So ground coverage is defined as the ratio of the ground floor area occupied by the building divided by the total area of the building. That gives you the proportion of the, or you can say the percentage of the ground coverage of the total plot area. So it is calculated as the percentage of the total plot area. The permissible percentage of the ground coverage is dependent on the land use as well as the plot use. So the dimensions of the ground coverage are marked by setbacks. So as we have already discussed, how a building is constructed is depending upon the area, or you can say the setbacks which are provided in front, side, and the rear side of the plot as per the municipal limits. After that, the area what is remaining will define the building area of your project. Now talking about floor area ratio, it is the quotient obtained by dividing the combined covered area, that is you can say the plinth area of all the floors except areas specifically exempted under these regulations, divided by the total area of the plot, will give you the floor area ratio of the building. So now you can see from the figure. So suppose this is your total plot area, or you can say the building line of the project. Okay. So this is your total plot area, and if you take the area of your each floor, so this is your one floor, this is your second floor, but since in second in first floor you can see some space is left that is open, so that will not be considered. So if you add the total floor area divided by the plot area, it will give you the floor area ratio of that particular project. Okay. So the aspects that govern in specifying floor area ratios depend upon the occupancy class of that area, what type of construction that is required to be constructed. Most important feature is the width of the street fronting the building and the traffic load. Fourth is the locality where the building is proposed and its corresponding density. Fifth is the how the parking facilities is available in that area, what kind of local firefighting facilities is available, how the water supply and drainage facilities are available. So that all defines your the floor area ratio of that particular project. So the height and the number of stories are related to floor area ratio. In some states, in some state bylaws, the maximum height of a building is dependent upon the width of the street. This is also an important point that in some states, the maximum height of a building is dependent on the width of the street abutting the building. So, following structures are not included in height restrictions unless the aggregate area of such structures exceeds one third of the area of the roof of the building upon which they are erected. So they include roof tank and their corresponding supports, MOMT, which is not exceeding 3 meter in height, chimneys, parapet walls, architectural features, which should not exceed 1.2 meter of the height, and sometimes it should include the air conditioning, lift rooms, and some service equipments, or you can say service room that are provided in different areas. So they should be they are not included in that particular structures. Okay. Now we have different parking norms also, depending upon the area we are living in, depending upon the type of population in that area, depending upon how much the traffic load in that area, also depending upon how much is the width of the street of that particular locality or area. So an enclosed or unenclosed, covered or open area sufficient in size to park vehicles is given to you, and the parking spaces should be served a specific driveway by connecting them with street and alley and permitting ingress and the egress of the vehicle. So that means it should not have the direct, depending upon the type of the car you have purchased, it should not depend upon that. And that means depending upon the area of the car, that should not be your the parking area. You should keep certain distance additional so as to maneuver your car to put it inside the building of your structure. So it is governed by the factors of land use, built up areas. So these parking norms are specified in terms of equivalent car space. Okay, so what is equivalent car space? Equivalent car space is defined as the minimum parking space, which also includes your circulation area required by the building. Okay, so for an open parking, your equivalent car space is 23 meters square. Whereas in case of ground floor, since your now area is restricted, so your equivalent car space increases to 28 meters square. But sometimes in case of basement, some people used to park the vehicle in basement, then your vehicle movement is further restricted. So in that case, your equivalent car space will increase, and now it increases to 32 meters square. So these bylaws, so we are not concerned about the values. We are concerned about how these equivalent car space or how these norms should be, means how these should be considered in our structure, so that it should be implemented in a proper way. So we are so that means we should be knowing that in case of open parking, we require less equivalent car space compared to ground floor and the basement area. So these definitions helps you to recognize that in which area you want to put more space regarding the particular purpose that is required to be served. Now we will talk about contract management. So few building laws we already covered. Now we went to contract management, how the contract management is done. So generally speaking, companies usually have some standard form of conditions which seeks to divide the responsibilities in the following operations. That is, one is pre-bid stage, second is execution stage, and third is post-execution stage. That means bidding, before uh, construction. So before construction, many parties are there. Many parties are there who will be interested in carrying out a particular project. Okay, so this is your pre-bid stage. Now, after the contract is made, few, or you can say one party will be selected out of all of them to whom the work will be allotted to carry out that particular work. So this stage will be called as the execution stage. Okay. Then after execution stage, the stage which is remaining for you will be your post execution stage. Okay. So for a good contract, there should be a proper objective. That is, there should be some certainty of the objective. Second, it should be have a proper commitment to meet the obligations, and it should provide a medium to communicate between the parties concerned, that is client and contractor. Okay, so contract is a medium which helps to communicate between the contractor as well as the client, because this medium helps you the proper guidelines which are available, so that you can argue with each other that what are the conditions that are mentioned in the contract, and you are supposed to follow that instructions based upon the legal document that you have signed during the contract agreement. Okay, so common reasons, there should be some common reasons regarding the disputes that occur during the execution stage. It could be providing incorrect ground data, or contract contains some faulty and ambiguous provisions, faulty administration of the contract, deviations, or sometimes like happens, you require some extra items in the project which are not included in the contract agreement. Then how they should be executed, whether you will create a separate agreement for that, or you for them that you say it to be supplementary contract, or you will try to include these items in other quantities that are specified, so that your total cost of the project should not change. So these depend upon the mutual agreement between the client as well as the contractor, and how the escalation of the rate is also considered, because when the project is very long, inflation changes the rate of the project, or rate of the item or quantities that are required to be utilized in the project, or you can say how the rate of the cement, sand, or steel is changing, or if you are talking about other project like road project, how the rate of the tar, bitumen is changing, how the rate of the equipment is changing. So rate escalation, how that is utilized in the project, that should also be taken into consideration. Then sometimes suspension of work will also occur. So like in COVID-19, the work got suspended due to unforeseen measure, that we call it as forced measure. Okay, or due to some cases in the high court that are developed, and that causes the work to stop, and there could be many delays in the project. You can say site got obstructed due to heavy rainfall, and landslides is occurring in that area. So all these factors should cause the dispute between the client as well as the contractor. So various other reasons are also there, that should include the owners are not handing over the site. That means land is not properly handed over the contractor to work upon, and now the contractor is fully equipped in the site with all its labor as well as the equipment. Then how he will start its work. So the more the delay will happen, the more will be the loss of the contractor will occur for the project. Another is contractor being of poor means, defaults by contractor, unreasonable attitude adopted by the contractor or client, delay in payments, and observations arising due to technical examination of the works. So, in case the engineer in charge who is provided to be inspect the particular amount of work that is completed by the contractor, then how he is uh, examining the work, that may also create the dispute between the contractor and the client, because client always supports the work that is already completed, because he don't want any reconstruction of the work to carry on, because that may cause losses to him in the total amount of the project. So that's why observational changes may cause dispute between the client as well as the contractor. So, what are the various parties or what are the various features that are included in the contracts? So, one is the parties of the contract. That means who is having the authority and power of attorney to execute the project. Second is purpose of contract. It may include what kind of project is required to be done, what are the obligations or what are the eligibility criteria that is provided for carrying out that particular activities, what are the prerequisite and the products that are required to carry out that particular project. So that includes the purpose of the contract. Third is governing laws of the contract. So that includes what are the status of the parties, acts and laws which are applicable and which prevails in case of disputes or disputes regarding the statutes or the contract terms. Another is implication or obligation of changes in the statutes, subcontracting of the word, patent and copyright related to different words. Then another thing that includes that is scope of work. So the scope of work should always be clearly defined, because if the scope is clearly defined, then in no case their dispute will start between the contractor as well as the client in any stage of the construction. So clauses like scope include something but not limited to something, and any other term considered safe for construction facilitate completion. So all these clauses should be properly included in the contract agreement, that should not cause the dispute between the two parties. So how the variation of the scope is provided, how the extra work and the extra time is included in the contract agreement. Then if we talk about the price, is the price is fixed or variable? So if it is variable, how the base rate, base date is defined, what kind of formula is adopted for price variation calculation, how much amount of ceiling is provided, how to take index regarding the calculation of the price variation, how the foreign exchange is considered, what kind of taxes and duties are considered for the price variation, that should also be provided in the contract document. So it should, another thing it should provide is the time and schedule. So these are the basic things, that is what will be the start date of the project, what will be the end date of the project, what will be the total duration of the project, how many delays could occur, and if delays occur, whether they will be solely attributed to the contractor or it should be attributed to client also. And if not attributed to contractor, who are the other ones to whom these delays should be attributed. Another is force majeure. So force majeure is like unlikely event that happens in that particular region that may occur due to one example I already told you, COVID-19. Another example you can say some you can say if you can say Kedarnath disaster that happens. So if that kind of disaster happens, if cloud bursting happens in a particular region, that is so devastating that it will cause the delays in the project for months or you can say for years. So that is what force measures. So what comprises in force measures, it is strikes, terrorist acts, act of god. So all these includes the force measures. So action or relief in case of force majeure, how it is done, that should also be provided in the contract agreement. Then in case of inspection, so how the inspection will be done, whether it will be done through third party or the purchaser, and when, what will be the time limit for having that particular inspection, and who will be responsible for the expenses that incurred or that occurred during the inspection time. Then regarding the insurance, so whoever is working the site, that is laborers, whether they are insured or not, if the equipments are working, so whether they are insured or not, that should also be properly defined in the contract agreement, and who should be responsible for the payment of that, whether client is responsible, or you can say a contractor is responsible for the payment of the insurance. So if client contractor is responsible, then he should be knowing that, well, how to include the amount of that uh, particular description in the contract agreement. So terminology related to insurance should be properly defined. What kind of liability he is expected to incur, that should be properly defined. How much premium that is applied, they should be properly defined in the contract agreement. And finally, the completion of the project, it should say that it should provide supply, erection, testing, commissioning, trial operation, or any other event, how the completion of the contract is performed. Then clearing of the site, what kind of extra material is required, what kind of packaging material that is required, how is the warranty. So if the warranty, that is, you can say, defect liability period, so what will be the start of that warranty, for how many uh, period this warranty is provided, what are the scopes that are included in that warranty, and what are the liabilities related to that particular warranty. So in case the work is not carried out as per the satisfaction of the engineer, or that may causing an effect, or not or the contractor is not doing the work in proper sense, then some damages should be incurred on the contractor. That means if you, I can say if I give you an example, that a particular uh, portion of the concreting is required to be to be completed. So the contractor has completed three-fourths of the concreting work, and the remaining one-fourth he is not going to going to author. He is telling you that it is not under the scope, but as per your contract agreement, it is already in the scope of work. So in that case, if he is resisting to do that work, so then liquidated damages should be applied on him, so that the work should be completed based upon the amount you have considered from the liquidated damages. So the compensation that you have taken from the contractor for the part of the work that he has not completed should be considered as liquidated damages. So it should have proper definition. It should have extent, how much percentage you are considering, and what is the maximum limit of the liquidated damages that can should occur on a contractor should be properly defined. Then over to the liquidated damages, penalties. So if the penalties is provide incurring over a particular contractor, then how the penalties considered, and uh, means up to what level of mistake or what level of negligence of the contractor, how much will be the penalty for that purpose should incur, should be properly defined. Then for the contract completion, concrete closure and concrete completion should be properly defined. Then in case of dispute resolution, some mediation and conciliation that is provided should also be included. Sometimes arbitration and related issues should also be considered. So what is the jurisdiction of that particular uh, arbitration or the dispute that is authoring should also be defined. That means generally the companies belonging to their native state keep the jurisdiction to that particular state. Suppose in case of DMRC, if I take it as an example, so DMRC usually try to keep the uh, jurisdiction as the Delhi Union Territory for all the disputes related to particular work. Then we can say Bangalore Metro usually try to keep the jurisdiction in the Karnataka state. Okay, so these are the example that how the jurisdiction is defined. Then, then how the contract often takes into account the different components. So in case of any construction contract, first feature that is included is the contract drawings. Another is specification of the work that is required to be completed. Then you have GCC or the general condition of the contract. Then you have SCC, that is special condition of the contract, contract agreement, bill of quantities. So all these components determine your total, or you can say all these components comprises the contract agreement that is required to be completed. So for any contract document to be prepared, it should include first the contract agreement. Second, it should include the specified drawings. It should include the specified specifications. Then it should include the bill of quantities for the work required to be completed. It should include the journal condition of the contract and the special condition of the contract that will provide all the necessary definitions in a regular sense so that it acts as a medium of communication between the contractor as well as the client. But now, in case of a discrepancy that is happened, so in that case, what preference should be considered? So first preference should be given to the description of the schedule of the quantities that is provided in the contract agreement. Then particular specification and special condition. Then on drawings. Then CPW specification and BIA specifications will come into picture. So for any project, whatever mentioned in the contract document comes first. Then the journalized definitions based upon the CPWD specification, or you can say Indian standard specifications, will come into picture. So all these preference order is given in the contract agreement. So it provides you what order should be followed in case of any discrepancies. So what is defined as a contract? So as per Indian Contract Act 1872, contract is defined as agreement which can be enforceable as such, having been made by free consent of the parties by persons competent to contract for a lawful consideration and lawful object, and which are not expressly declared to be void by any statute. Okay, so this is the proper legal definition for the contract. So, what are the features of the contract? So, there must be a mutual agreement between the two parties. There must be an offer made by one party called as promisor. There must be another party called as promisee, which must accept the offer. There must be considerations for the doing of an act by an promisee for the promiser. Then the offer and the acceptance should relate to something that is not prohibited by the law. So the contracting parties entering into the agreement should be competent. That is, they should not be disqualified by infancy incentive to make such agreement. So the offer and the acceptance constitute an agreement which, when enforceable by law, becomes an contract. So this is the basic definition regarding a contract, which tells you the offer made by the promiser to the promisee When it become the legal binding between both of them, that will become a contract. Okay. So what is an agreement? So agreement is every promise and every act of promise forming the consideration for each other constitutes an agreement. So all agreement or contracts, if they are made by the free consent of the parties competent to contract for lawful consideration and with a lawful object, and are not hereby expressively declared to be void. Okay, so this will be the definition of the agreement. So how you define the contract? So contract is defined in two parts. One is the agreement, and one is it enforceable by law. So what it is included in agreement is the competent persons and their corresponding parties. What kind of proposal is provided, whether there is acceptance by the by the promisee regarding the particular proposal, and what consideration is considered for the carrying out that such particular project is also it to be considered in agreement. Then enforceable by law includes an intention to create a legal obligation to follow legal consequences. So one is giving you the all the things that are required to be taken into consideration, but they should always be in correspondence to the laws which are pertaining to the contract for which the promisee is required to do and complete the work within such limited time. When it is enforceable by law, it becomes a contract. Now, what is a lawful object? So, anything which is non forbidden by law, not defeating the provisions of law, not including or implying injury to the person or the property. Court does not regard it as immoral, and which is not opposed to the public policy. So all these things will contribute to what is lawful object. Now, what is a valid contract? So if you say what is a valid contract, so a valid contract should satisfy all the following conditions. First is the offer and its acceptance, its intention to create legal relation, what is the lawful object that is provided, which are the lawful consideration that are considered, who are the competent parties which are considered, free and the genuine consent, agreement which is not declared void otherwise, and the certainty of an object and possibility of performance. Okay, so now what is, so earlier we have seen what is valid contract, now we will see what is void contract. So void contract is the one which is entered by the incompetent parties, which is taken into consideration and objectful as unlawful, which is forbidden by law, which defeats the provisions of the law, which involves or implies injury to the person or the property, to which the court considered to be immoral, and which is opposed to the public policy. So, whatever the reverse of the valid contract will take into contribution for the void contract. So when this void agreement can be voided, so whenever, so under what condition an agreement can be voided? So an acceptance obtained without free and genuine consent by coercion, undue influence, fraud, misrepresentation, and mistake is under such condition the contract is considered to be void. So an agreement without consideration except for natural love and affection, promise to compensate in voluntarily service or compliance of law, promise to pay time barred debt, gift actually made, and creation. So they are all should not be the part of an agreement. Okay. So now giving you an definition for a dispute. So a dispute implies on the assertion of a right by one party and repudiation thereof by the other. Okay. So hence a mere claim without repudiation cannot be a dispute. So whenever there is repudiation, then only dispute will occur. Now, what is mediation and conciliation? So, an informal process where the parties are assisted by one or more neutral third parties in their efforts towards settlement is considered to be the mediation and conciliation process. So, these mediators do not judge or arbitrate the dispute. So, they are provided to advise the parties to assist in bringing about a mutual acceptable solution for the dispute that is authored. So, before going to arbitration, a mediation helps them to solve the matter in between the two parties who are concerned regarding that dispute, so that before going to the arbitrator, if the dispute can be resolved outside them, that is beneficial for both of them. So, given the very nature of the process, the mediator have no power to impose an outcome on the disputing parties. So, what are the techniques of the mediation? First is pre-mediation. So, in pre-mediation, it includes agreeing to mediate and preparation, initial inquiry and engagement with parties, preliminary communication and preparation. Then we have direct and indirect mediation, which includes meeting the parties' presentation, the information gathering, allowing them to have the proper negotiation between the two, terminating mediation and recording agreements. So these all comes in direct and indirect mediation, and post mediation complies to what is the outcome of the particular dispute that is going to occur. So that helps in the post mediation process. Now, what are the benefits of mediation? So mediation helps in faster and the cheaper disposal of any dispute. It is a more satisfactory outcome of the dispute. It minimizes further disputes between the two parties, and it acts as an open channel of communication between the two parties. It preserves and enhances the relationship between the two parties, and it empowers the parties to set up their point based upon the dispute that is occurring between the two of them. Okay. Now, if the means if the dispute is not going to be resolved by the mediator, arbitrator comes into picture. Now, how the arbitrator is going to be selected? Because if it is selected by client or contractor, that will become a biased decision. So, how the selection of arbitration is done? So, so a selection of arbitrator depends upon a person of high integrity and complete impartiality. So that person believes in applying principles of natural justice and of practical approach. So that person should have a technical knowledge with the proper domain for which the dispute is concerned, and he should understand legal procedure and able to understand implication of any failure or inability of either party to comply with proper requirements and relating to evidence. Now, what are the duties of the arbitrator? So the duties of arbitrator includes, now on the appointment of an arbitrator, to check whether he is qualified or not, we have to understand the issues under disputes either through a meeting or send the notice to parties and ask for statements and submission by the parties. Then necessarily disclose to parties about his knowledge of the case, and having dealt with the case, he should not receive any evidence in absence of other parties. He should not examine a witness In absence of any of the parties, he should not make private inquiries, he should not delegate authority, he should not exceed the scope of reference, and he should adhere to the time and the schedule which is laid down to complete this dispute process. Now, for the conduct of hearing, administrator oath to parties and witness them to appear. So, in proceedings, the claimant makes an opening statement. That means whoever makes the claim for that dispute makes an opening statement. Then the claimant calls and examines his witnesses who may be cross examined by the respondent. Okay. If a witness is cross examined, the claimant may re examine him on any matter raised in cross examination, but he cannot again ask the question which he has already asked during his first examination. Okay. Fourth, the respondent then opens his case. Then the respondent calls and examines his witness who may be cross examined by the claimant. If a witness is cross examined and the respondent may examine him on any matter raised in cross examination, then the respondent addresses the arbitrator, summing up the whole case. Then the claimant submits a reply. Okay, so this is the whole process how the proceeding happens when the case goes to the arbitrator. Now, what are the advantage of arbitration? So first is it is a formal and the quasi judicial process. Second is decision can be imposed now. It provides cheap and quick decision and generally better suited for technical disputes. Experts, legal, and the technical advice can be obtained from the arbitrator also. Site of the words can be visited. Interim relief can be granted. No publicity is involved, and the time and the place of hearing can be fixed as per the mutual convenience. Now, after the legal aspects, we will move on to what are the different types of contracts which are available to be carried out. So we have a turnkey, or you can say EPC kind of a contract, which is engineering, procurement, and construction contract. Another contract that is available to you is the lump sum contract. We have measurement contract also, in which item rate contract, percentage rate contract, and the rate only items comes into picture. Then we have cost plus contract into consideration. Okay. Now, what is turnkey contract or EPC contract? So, a turnkey contract is one in which the contractor is responsible for both design and the execution. Here, the owner obviously still provides the functional requirements and approves the design and the drawings. Then the contractor will provide the works ready at a fixed time and and an agreed rate. Then the term is used synonymously with package contract, design and build, or design constructor. Okay, so these contracts are known as the EPC contract. Okay, wherein the constructor comes into picture. Package contract, that means whole package, whole thing is provided to one contractor. Design and build, whenever these words come into picture, that are referred to the EPC contracts. Now, what is lump sum contract? So, a lump sum contract, or you can say fixed price contract, is a type of contract in which single sum amount is paid for all the works which are required to be performed. So, in this contract, the contractor is responsible for completing the project within the agreed fixed cost stated in the agreement. So, this agreement is normally used in the construction industry to reduce the design and the contract administrative cost. This contract is simple to administer and more suitable for simple and the small project where the project is already well defined and the changes are unlikely. Okay. Now talking about the measurement contract, which nowadays is most widely used. So measurement contract sometimes called remeasurement or measure and value contract, can be used in situations where the design or the types of work can be described in reasonable details, but the amount of them cannot be. Based upon the quantity and the price already declared in the contract agreement, based upon that, the total amount will be calculated. So the measurement contracts allows an early start on site before design is complete, and they can allow changes to be made to the words relatively easy. So for example, excavation works where the quantity of excavation required is difficult to access until all the work have begun, or refurbished projects where there are uncertainty about the works that are required to be included. So these are the cases where you know the items that are required to be utilized in the project, but the quantity that is specified in the contract is uncertain. It could increase based upon the type and the requirement of the project side, and it should also decrease. But the rate which is specified in the contract during the bidding phase, or you can say just after completing the bidding phase of the contract, the price which is finalized in the contract agreement will be binding for the contractor throughout the construction progress. Now, what is item rate contract? So, item rate contract is also known as unit price contract or scheduled contract. So, a contractor undertakes the execution of work on any item on item rate basis. So, here the work is carried out based upon the item rate that is provided. So, in this case, the contractor will provide the rate for each and every item that is required to be completed, and then the total cost of the project will be calculated. So, here the contractor is required to quote rate for individual item of the work on the basis of the schedule of the quantities, that is the bill of quantities furnished by the owner or the client, and the amount to be received by the contractor depends upon the quantity of work which is actually performed in the site. So the payment to the contractor is made on the basis of the detailed measurements of different items of the work which is actually executed by the contractor in the site. Now another thing which will include in the measurement contract is the percentage rate contract. So in this form of contracting, the client or the owner draws up item rate tender, that is bills of quantity and its corresponding amount. Now contractor are required to offer or carry out the work as per with the rates shown in the specific price schedule, or some percentage above or some percentage below the rate indicated in the schedule of the works attached to the tender. So that means with the percentage rate contract, in which the client already is providing you the bill of quantities or bill of what you can say bill of quantity and schedule of rates. Based upon how the rates are derived, is it's up to the client that how he has derived on the rates. Now it's the now the ball is in the court of the contractor to decide that what percentage above and what percentage below he should quote, so that that work should be completed and the contractor should gain necessary profit from the project. Okay, so rate only contract. So these contracts call for the tenders to quote only their rates per unit of the work or of different kinds. They are used for the works whose quantity cannot be defined in advance, such as site investigations, grouting work, sinking of boreholes, and any other quantities which is entered in such contracts will be for indicating the amount of work expected, and it do not form the basis of the contract. Okay, so rate on the contract will provide you only the rates, then the actual quantity of the work that is required to be completed, which may so that quantity may be utilized or may not be utilized in that particular project, that is uncertain. So if that is utilized, The rate at which the mutual agreement between the client and contractor happened is paid to the contractor. Now, what is cost plus contract? So, cost plus contract, also termed a cost reimbursement contract, is a contract where a contractor is paid for all its allowed expenses plus additional payment to allow for a profit. So, the cost reimbursement contract contrast with the fixed price contract, in which the contractor is paid a negotiated amount regardless of expenses. Okay. Now, earlier the types of contract we have seen, they were the base contracts we were using in the day-to-day life of the construction projects. Now, few types of projects are nowadays emerging, and some parties are now utilizing them in their projects. So, what that include? So, one is FIDIC contract, another is PPP, that is public-private partnership contract. So, what is FIDIC? So, FIDIC is defined as the International Federation of Consulting Engineers. So that was founded in 1913 in Europe with secretariat in Switzerland. So the FIDIC form of contract has evolved over a period. The contract conditions are equally suitable for use for domestic contract. So before 1999, FIDIC has three forms of building and engineering contracts. So that includes red book for civil engineering construction, yellow book for electrical engineering and mechanical work construction. Third is orange book, okay, for design and build contracts. But in September 1999, four new editions were published, which are in use now. So, what are the principles of FIDIC contract? So, it is to achieve optimum results by not expecting the contractors to quote for risk that would be reasonably unforeseen, that would be reasonably foreseen and evaluated. Second, for the employer to assume responsibility of the cost and arising from the events that may not never occur, which lie outside the contractor's control or which cannot be covered by insurance at a reasonable premium. Okay. Third, it includes the close cooperation and the teamwork between the employer or the contractor and the engineer within the framework of the contract with mutual desire to produce a satisfactory end product. Then, to remove the mistrust and the lack of confidence with all parties performing their duties under the contract responsibly and correctly. So the use of independent engineer who is required to exercise his discretion with impartiality, even if he is an employee of an employer. Okay. Now, what are the features of the FIDI contract? First, it is balanced. So fair proportions, apportions of risk, rights, and obligation between the parties are provided. Second, it is well tried. So long case studies for earlier contracts is already there. It is nowadays widely accepted. So it is known and recognized in wide use for international contracts. It is always supported because it is recommended and required by development projects. Fifth, it is effective because it provides clear, complete conditions and time limits and provisions of attributions. So there are few conditions of the contract for construction and for plant and design waste materials. So these includes the set of conditions recommended for building or engineering works, where the employer provides most of the designs, sometimes including the certain contractor designed construction work that includes red logo. So for the civil engineering construction, red logo come into picture. Now, for the plant and design based conditions of the contract, these includes the set of the conditions recommended for the provision of the electrical and the mechanical plant, and for the design and the construction of the building or the engineering works, where the contractor designs and provides in accordance to employer's requirements. Then we have condition of contracts for turnkey projects. So these includes the set of conditions recommended for projects of turnkey basis, where the contractor undertakes the total responsibility for the design and execution of the project, including the guarantees of the performance. Fourth is the short form of the contract. So this type of contract is mainly suitable for the small works and for small duration or small repetitive works for any discipline of engineering and for who provides the engineering, irrespective of who provides the engineering. So for them, depending upon the types of work that is required to be completed, different logos are given to them. So we have given red logo for construction contracts. We have given yellow logo for plant and design based contracts. Then we have given silver logo for EPC and turnkey contracts. And for the short form of contract, green logo is given to you. Now you can see the obligations between the two types of contract. One is MES contracts and another is FEDIC contracts. So in MES contracts, obligation of contractor are spelled out clearly, but those of the owner or you can say client are not expressed clearly, comma, duties in particular. But in case of FIDIC contract, the obligation of the contractor as well as the owner, you can say client, and the engineer are set out clearly. In case of MES projects, the security deposit may be refunded to the contractor after the effect expiry of the defect liability period. However, there is no timeline which is specified for such refund and it is not linked with the taking over of the work. Whereas in case of FIDIC contract, it is mentioned that the performance security shall be returned to the contractor within 14 days of the issue of the defect liability certificate. But in nowadays, in general contracts also, people are nowadays become very aware and they want their money as soon as possible. So for them also, money is going to disperse them back as early as possible. So, engineer in an MES contract is an employee of the department who administers the contract and works as a representative of the owner to settle all the matters which arise in relation to the construction. Whereas in case of a FIDIC contract, the engineer may be the employer of the employer department, but it is not, but he is not a signatory or the party to the contract between the employer and the contractor. He has to perform as an interpreter of the contract and judge of the performance by both the parties. Engineer in an MES contract takes the decision by taken by engineer. So in this decision taken by engineer or accepting authority under some clauses are final and binding. So in that case, you can't argue with them based upon the types or clauses that are provided in which final and binding is mentioned. So whereas in case of FIDIC contract, decision or opinion taken by the engineer may be opened up, reviewed, and revised by the arbitrator if challenged within the stipulated time. So in MES contract, work that radically changes the original nature and the scope of the contract should not be ordered as a deviation. And in the case of event of disagreement, the engineer's decision shall be final and binding. Whereas in FIDIC, the engineer can make any variation of the form, quality, and the quantity of work, or any part thereof that may, in his opinion, is necessary. So the deviation should not be more than the percentage set out in the contract document as per MES, whereas in FIDIC, There is no deviation limit specified. However, if the deviation exceeds 15% of the effective contract price, then in such an event, the contract price shall be adjusted. Now, in case of an MES contract, the engineer shall issue a certificate to the contractor if the work is completed to his satisfaction. However, there is no time frame for issue of such certificate which is given in the contract. Whereas in FIDIC, the engineer shall issue a taking over certificate within 25 or 21 days after the receipt of the contractor notice and understanding if work is substantially completed in his opinion. So this is FIDIC contract. Now we talk about the PPP contract. So PPP contract is a partnership between the public and the private sectors with clear agreement on shared objectives for the delivery of public infrastructure and public services, especially in transportation and power sectors. Like I already told you, this model is nowadays utilized by NHAI for carrying out the construction work. So essentially, it is an arrangement between the major stakeholders in an infrastructure project, which could be government, statutory bodies, public entities on one side, and the private entities, including the financial institution on the other, to provide the public assets or the services with the investments being made or the management being carried out by the public sector entity for a specified period of time under supervision of the government or the regulatory bodies. So what happens in PPP projects is like the contractor is given the whole work to construct the road, to maintain the road, and to operate the road also. That means to collect the toll from the road. So the toll from the road will be its compensating power for the amount he has spent to construct that particular road. So he will provide the time for which we will provide the toll at that particular point. So suppose he is providing that he will collect the toll for 20 years, and after 20 years the work will be handed over to the government. But for the 20 years, he will collect the toll on regular basis, which will accumulate to the total amount he spent in the construction of that work. However, so in some case, addition to the amount should will happen, and that should happen. Then only the profit to the contractor will be made. So in that case, the time limit that is provided in the contract, suppose we can say in case we say 20 years, so then up to 20 years, whatever amount he is getting, that will be in the pocket of the contractor. So in this case, we have many stakeholders also. One is the host governments. So normally the government is the initiator of the infrastructure project and decides if the BOT model is appropriate to meet its needs. So the government provides normal support for the project in some form. Now, second is consignary. So the project sponsors who act as a consignary creates a special purpose entity which is capitalized through their financial contribution. Then lending banks, because funding should also be required to complete that project. So the most BOT projects are funded to a big extent by commercial debt. So the bank will be expected to finance the project on non-recourse basis, meaning that it has recourse to the special purpose entity it and all its assets for the repayment of the debt. Then other lenders, the special purpose entity might have other lenders such as regional development bank, national development banks. So in India, we use different models. One is BOT, that is build, operate, and transfer. Another is BOOT, that is build, operate, own, and transfer. Then it is build, own, and operate. Then we have design, build, finance, operate, and transfer. Another we have boost kind of project, that is build, operate, own, share, and transfer. So all of them definition is provided to you that for what stream how the work should be carried out. Okay. So If you want, I will in these slides will be provided to you. You can read about them in detail from these slides. So this is for the bot scheme, build, operate, and transfer. Then you have for the design, build, and operate scheme, how they are linked. Then you have build, own, operate, and transfer. Okay, so these are the definitions for the different kinds of models that are available in India. Now we will talk about some important definitions also which are related to the project. That is, so first of them is earnest money deposit. I think we have started in the starting of the project also, we have covered some of these definitions. But since this is the last problem solving session, so let's recall some of them. So earnest money is the deposit made to the client or the owner, showing the bidder's good faith in the transaction. So in real estate and the similar transaction, earnest money allows the buyer to gain an additional time when seeking the finance. So how it differs with the retention money and the security deposit. So retention money is the amount which is withheld for some time after the agreement has been fulfilled. So its purpose is to ensure the contract has been properly performed by the service provider or the supplier, whereas the security deposit is the amount given by the depositor such that he does not complete if he does not complete the work as per the work order, the owner or the client can recover the loss by forfeiting or by using a part of this security deposit. Now, what is BG? That is bank guarantee. So, bank guarantee is a promise from bank or the leading institution that if the borrower defaults on repayment of a loan, the bank will cover the loss. So, the contractor often use bank guarantees rather than lock their own capital with the client. So generally, it lies if you require 1 crore of the earnest money. So if you take bank guarantee from the bank, you are required to provide only 25%. That is 25 lakh of the total earnest money that is required for the project. So in that case, 75 lakh of the contractor is already saved. Okay. So now what is secured advance? So secured advance is an advance payment made to the contractor on the basis of security of materials brought by the contractor to the site under construction. You can also say provide it as the mobilization amount. So secured advance is also described as the mobilization advance. So now what is maintenance period and the defect liability period? So maintenance period is the period following completion of the construction project during which the contractor is responsible for the certain maintenance issues under the building or the engineering contracts. Whereas defect liability period is a set period of time after construction of the project has been completed, during which the contractor has the right to return to the site to remedify the defects. Okay, so this is the difference between the maintenance period and the defect liability period. Now, some more definitions regarding uh, penalty. So, in a contract, the parties may name a sum of a sum to be payable in the event of breach. So, if the sum is genuine, pre-estimate of loss, then it is termed as liquidated damages. So, and if it not bears any reflection of the loss which is suffered by the client, then it is said to be penalty. So when the estimate of the loss is uh, quantitatively, that is all the quantities quantity of the loss is properly defined, then it is termed as liquidated damages. However, when you are giving an overview of the total amount of loss that is happened to you and you are not providing the exact amount of the loss incurred, then it is said to be a penalty. We have another definition also, that is quantum merit. So quantum merit determines the amount to be paid for services when no contract exists. In other words, it refers to a reasonable sum of money to be paid for services rendered or work done when the amount due is not stipulated in the legal enforceable contract. Okay, that means the initial amount that is provided to the contractor, it is termed to be the quantum merit. Then what is arbitrator and what is who is umpire? So what is who is arbitrator and who is umpire? So an arbitrator is a person which is mutually agreed upon and selected by the parties to hear the dispute, whereas an umpire is a person chosen to decide a question in a controversy that has to be submitted to the arbitration but has not been resolved because the arbitrators cannot reach an agreement. So in some case, what happened then arbitrators also could not reach an agreement. Then umpire is the one who is the responsible person to decide and provide the resolution to the arbitration committee. Then we have sub judice. So sub judice means a particular case or matter is under trial or being considered by the judge, court, or it is not decided. So when the matter has yet to be proved or disproved in the court, it is sub judice or unable to be discussed or stated as a fact in public. Okay. Now, what is an award and what is a decree? So an arbitration award is the determination on the merits by the arbitration tribunal in an arbitration, and it is analogous to the judgment made in the court of law. So it is referred as an award, even everywhere of all the claimants uh, claims fail or the award is of non monetary nature. So few terms also they are also considered in the arbitration cases. One is the you can say first line that in a non-speaking award, the company was directed to make a payment of US dollars 5,000. So that means when you can't provide the proper justification regarding the dispute, then you provide or you orders the company to pay a certain amount of money to the client based upon nothing because you have not reached to the conclusion of the dispute that has happened. So that is what is told as non-speaking award. So what do you mean by set aside? So the judgment was set aside by the higher court. Set aside means the higher court has uh, withdrawn the judgment that is provided by the lower court. Okay, so that is meant by set aside. Now, what is status quo? So, if you have seen the module, it is mentioned that so the like here it is mentioned that the code has directed the status quo to be maintained. That is, suppose in in a property, if a person A is living first, then after that, by paying some amount that we don't know that whether it is controversial or not, person B is now starting to live. Then now person A comes and creates dispute between between A and B that who will be the proper resident of that particular project. Then the court orders that the person who is currently living, that is the person B, will be the actual resider of that of that particular property. That is status quo. Whereas in case the court orders the person who is earlier residing, that is person A, will be the actual resident of the project, then it is set as status quo ante. Okay. Now let's have some discussion regarding definition of assets. So assets are the items of value owned by the company either as cash or otherwise, which is convertible to money. So assets are of two types. One is the fixed assets and another is current assets. So fixed assets can be tangible and can be intangible. So tangible includes land, plant, machinery, buildings, etc. Whereas intangible includes copyrights, patents, goodwill of the particular person, and many more. Whereas the current assets includes debitors, cash, bank balance, stocks. So these are the current assets. Now talking about the liabilities. So liabilities are the companies that owes to others, which may be owners, shareholders, or financial institution. So liabilities could be the long-term liabilities and the current liabilities. So the long-term liabilities includes bonds, loans, mortgages, and many more. Whereas the short-term liabilities accounts for taxes to be payable, accrued expenses, and sometimes short-term account to be payable, and many more. So by this, I think we should end up all the discussions regarding the contract and what are the important definitions that everyone should know. So one code you should always remember given by Hammurabi Table, which is if a builder constructed a house but did not make his work strong, with the result that the house he built collapsed and so caused the death of the owner of the house, then the builder shall be put to death. So that means if a responsibility is given to someone to create a project which is of large value, and if that collapse, it will cause a great loss to the humankind, or you can say great loss to the persons who are residing in that uh, particular property. So if that person dies, the builder who is involved in that particular project should also be put to the death. So that means this is not we are giving you an like um violence kind of a statement that you should hit a person if he is hitting you. It's like you should follow proper rules and regulations that are provided in the documents, proper regular codes that is provided to you. You should follow proper quality control, follow proper standard procedures. You should not deviate from the material that is required to be constructed. Suppose if you require 20 kgs of cement to be added to the structure, you provide the 15 kgs and you try to save 5 kgs each day, and you feel like you are saving your money in the particular project, and that can be utilized and you can consider it to be profit, but it is reducing the strength of the structure in which the person will be residing in the future life, and that if may collapse can cause the death of the individual. That should also be taken into consideration. So every contractor should follow some proper ethics. So because for the amount, for the work that he is required to be carried out, proper amount is already paid to him or will be paid when the work is completed, and that work will be appreciated by the client also, that if he carry out the work in the proper manner, that will be appreciated by the client also, but he should not compensate with the quality of work to be done at that particular site, because in construction you can build anything, but if that collapse, that may cause the death of the individual. So some proper ethics should also be taken into consideration. So we have proper rules in US regarding the ethics. So we will discuss some of them, but that's only for your understanding purpose. That will not be your requirement for the course, but you should follow these ethics because that makes you a good engineer and that makes you a good structural engineer that you will become in the coming future. So the engineers will uphold and advance the integrity, honor, and dignity of the profession by using their knowledge, skill for the enhancement of the human welfare. So being honest, impartial, serving the fidelity, the public, their employers, clients, and then striving to increase the competence, prestige of the engineering profession, which in support of the professional and technical societies of the corresponding disciplines will be included as the fundamental principles of an engineer that is involved in the particular side. So what are the fundamental canons? It is that the engineer should hold the paramount, the safety, and the welfare of the public in the performance of the professional duties. So engineers should perform services only in areas of their competence. They should issue public statements only in an objective and in truthful manners. They should act in professional matters for each employer and client as faithful agents or trustees and shall avoid conflicts of the interest. Okay, so by this, let's end the discussions and let's solve one short problem related to what we have covered for the building bylaws. So, after covering this one example, we will close this session. Okay, so let's solve this problem. So, understand this problem in detail because this is your last problem of this session. So, consider a square plot of 40 by 40 meter. Okay, so let's draw one plot by 40 by 40 meter. Okay, and having a maximum ground coverage of 40%. That means out of this 40 to 40 or 40 by 40 meter, only 40% of the ground can be utilized. Okay, that is this 40 by 40 meter. Inside, we can make a building of which has the ground coverage of 40%. So, what is ground coverage? It is the area above the plinth divided by the total area of the building. Okay, another information is provided that is a setback of 6 meter and 10 meter is provided at the front and the back of the building. So if I can say this is the front 6 meter, this is the 4 meter. So this is the setback distance that is provided to you. Okay, so now you have to count the number of floors that will be required to fully utilize the given FAR of 2% of 2. So now what is FAR? That is floor area ratio. That is total built up area divided by total plot area, which is given to you as 2. Now first calculate area of the plot. So area of the plot is 40 into 40 equal to 1600 meter square. Okay. Now FAR is given to you as 2. So total built up area will be equal to 2 into 1600 equal to 3200 meter square. Fine. Now it is given to you that setback is also provided to you 4 meter and 6 meter that we have already provided. So the remaining area that is left with you is this one. Okay. So what we have given is ground coverage also. So ground coverage at 40% is equal to 0.4 of 1600 because the total plot size area is 1600. That will be equal to 640 meter square. But the area which is left out after the reducing the setbacks. So area after reducing setbacks will be equal to, if we take one side only, so 40 into 40 minus 6 minus 4, that will give you 40 into 30, that will be equal to 1200 meter square. So your ground floor area, so your ground floor built up area will be minimum of ground coverage, comma, a- area after reducing setbacks. Okay, this is only for the ground. Okay, so that will become 640 because we have to follow both the conditions that is provided to you, that is setback as well as the ground coverage. Now what is remaining is the top floor, how many floors we can add. Okay, so total area we can go up to is 32 meters square. Okay, so now we can add up to 32 meters square. So first floor, so after first floor, so this is for the ground floor. After consider ground first floor equal to 1200 meters square, second floor equal to 1200 meters square. Then what is remaining? So remaining built up area will be equal to 3200 is the total built up area minus 640 is for the ground floor built up area, 1200 is for the first floor built up area, plus 1200 is for the second floor built up area. That will accumulates to 3000 minus 3040, that will be equal to 160 meter square. So therefore your third floor built up area will be equal to 160 meter square. This implies number of floors that can be constructed will be equal to G plus 3 floors, or you can say total 4 floors you can construct. Okay, so this is the one basic problem related to what we have seen for the building bylaws. So if anyone has any problem, they can ask right now. I am waiting for the response. So by this session, we will conclude our the course of the principle of construction management. So on Wednesday also we will have one class related to the summary session, wherein we will try to over give an overview regarding the whole course we have covered during all the problem solving session. So in that session, we will not cover any numerical problems related to concepts what we have covered. That session is only provided to you so as to overview all the concept what you have covered in the last 8 weeks, so that that will helps you to recap what you have gained from the learning of the principle of the construction management course. So if anyone have any doubt, I am here. So if not, let's end up this class. It's already over time. Okay. So I will meet you on Wednesday. That is on, I think it will be on 18th. Yeah, it will be on 18th. So on 18th, we will meet up at 7 p.m. and then we will summarize whole course, and that will conclude your whole course regarding the principle of construction management. So thank you everyone. Have a nice day. Enjoy your whole weekend.